Yes, go ahead.
Good morning, Your Honor. And on behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this waiver for avoidance of all doubt.
Good morning, Your Honor. Rob Knopfring on behalf of our client, Ms. Jaleesa McDowell. We join in prosecutor's motion.
The court, for its part, also does not believe that conflict exists, either in the court rules or the case is decided thereon. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people versus Jaleesa McDowell.
And on behalf of the people, Your Honor.
Rob Knopfring on behalf of Ms. McDowell.
Ms. McDowell, can you state your name, please?
Jaleesa McDowell.
All right, this is the people's motion.
Thank you, Your Honor. Your Honor, at this time, the people would request the court set a bond of $50,000 cash surety. I'm aware it's already set. In this case, the people originally requested a $100,000 cash surety bond, and the magistrate granted a personal recognizance bond at the arraignment. This case stems from a 911 call from the victim's friend after she received a text from the victim saying that her mother had stabbed her and that she was scared to call 911 because the defendant had been threatening to kill her if she heard sirens. When officers arrived, they spoke with the victim, who informed them that she and her mother had gotten into an argument. And from that argument, the defendant grabbed a butter knife and stabbed a wall in the house and then stabbed the victim's hand. After stabbing the victim's hand, the defendant then forced her into the bathroom and yelled at her to take off her clothes and get in the tub. The victim refused, and this caused the defendant to then grab her around her throat, shove her into a wall, which caused her head to hit the wall. The victim informed officers that she was extremely afraid of her mother and fears that her mother will kill her. And the people have extreme concerns given this case and the fact that the victim had to go to the hospital for that stab wound that required stitches. We have extreme concerns for the victim's safety as well as the community's. This defendant also has another case that was recently charged, I believe was arraigned on Friday for an MDOP against her boyfriend. That case stems from incident in March of this year where the defendant chased her ex-boyfriend in a car and was throwing rocks at his car while it was driving down the road, resulting in damage to the vehicle. So at this time, the people would ask that the court set the bond at $50,000 cash surety in the GBHFA case and believe that the personal recognizance bond was an abuse of discretion, Your Honor.
Thank you.
John, I've had the opportunity to meet with my client prior to today's hearing. I wasn't present at the arraignment, so I don't know what facts were argued by the prosecutor's office. The only thing new that I'm hearing since the bond was set at personal recognizance by the magistrate on June 12th is the authorization of the malicious destruction of property charge, a 1-year misdemeanor, which my information is involved rock throwing. It did not involve the complaining witness, her 15-year-old daughter. It was a separate incident in March. So I don't know what information is new that is being presented to this court. As background, my client has 2 children that are in the household, a 12 and a 13-year-old who are currently, and I stretch to say unsupervised, but I think they're in the care of neighbors and friends, and they need structure as school is out right now. My client is gainfully employed at the mobile gas station at Haggerty Road and I-94, where she's a supervisor. Also, when she was arrested, her home was not secured, and her home right now, as I understand it, is unlocked, and people are helping themselves to the contents of her home. She lives at 1243 Stamford Court in Ypsilanti, 48198. And it's my information that the prosecution has not been provided or has any jail calls where my client has made any contact or had any contact whatsoever with the complaining witness. And as the court's well aware, had they been armed with this information that my client was attempting to reach out to her 15-year-old daughter, they would have presented to the court. So boiling this all down, we have no new information other than the rock throwing incident, which occurred in March. I'd ask the court to consider a $5,000 10% bond. The prosecutor, I believe, told me that the bond for the malicious destruction of property charge that was authorized and that my client was arraigned on was set at 1,010%. And also as a condition of this any release, this case, the instant case, any release would include release on a GPS tether. So we would have, the court would be aware of where she is at all times. And it's my information that the complaining witness, her 15-year-old daughter in this case, is not in the household. So there would be no problem with any unwarranted or any contact whatsoever. But my client needs to get out to save her job, help in the defense of this case, secure her home, and secure those two minor children that aren't in school. So I'd ask the court to consider a $5,000, 10% bond.
Well, I thought that the other children, as I was understood, were with, that their, I guess, care had been secured.
That's my information. I have not been able to verify it. Counsel that was assigned the case this morning called off, so I went to the jail and did due diligence as required by MIDC standards to meet with my client. I can't speak because on verifying that where those children are right now, but that's my information that I don't know their supervision right now. I haven't been able to ascertain that because I had to go see my client when I got the call from my colleague who called off.
Well, just so that we're clear, I watched the arraignment after receiving the motion. And my understanding was that the 15-year-old was with her grandmother.
Your Honor, per my notes, my other minor children are staying with the father, stepfather, and then the victim, the minor child, is staying with her grandmother. And then further notes indicate that the children were put with a brother or girlfriend who lives either next door or close to defendant's residence. So I'm not exactly sure at this time where they're staying. I know they talked with CPS, who is working on getting the grandma to be the caretaker at this time.
Okay, that was one of my questions, whether or not CPS was involved. But
And that's another concern of my client, not to cut you off, Your Honor, but with the tenuous supervision, as stated by prosecutor as well, there is a plan in place, but I don't know, kids being kids, I don't know how manageable they are. You've had 12 and 13-year-olds, Your Honor. You can't even get them to go to turn off the TV sometimes or come in when the street lights are off. You know what I'm
I don't
talking
know how
about.
your kids act.
Oh,
That was not my children.
oh, okay.
All right, so, but Ms. Zenda, these new individuals, I'll call them, that these children are staying with, does that include, at least based upon what you have, that the victim or the 15-year-old is there?
I believe so.
I heard the grandmother in Detroit. That's what I thought I heard.
Well, that initially was where she was going to be, but the other two were supposed to be with, I thought, at least as what I could understand from the arraignment, we're supposed to be with the father of the middle child. But now I'm hearing something different where all three children may be someplace in the same neighborhood.
I believe so. We received an email from DHHS that said the kids were with an Alicia Clark, who is the defendant's brother's girlfriend, and the residence of the address that they're at is, can we approach, Your Honor?
Yes. Should reflect at a pre-press conference, and the major subjects of the clear was the at least the last known address regarding the children that are involved in the case been put on record. That way, was there anything else from my other side?
Nothing from the people, Your Honor.
No, Your Honor, other than she needs to get out, take care of those kids. The two that she can have contact with, keep her job, and
Well, and maybe that raises another concern for the court. I became aware of the MDOP after, or at least the details of the MDOP after the court had made its initial decision regarding the magistrate setting a bond. But why should I permit, given what I hear, her to have any contact with children or anyone under the age of 18?
Because CPS will step in. And then that's a whole nother can of worms.
What is a whole other can of worms?
CPS investigating possibly.
Correct. But typically in cases that might be similar to this, where there's injury to a child, we don't, the bond conditions are set where there is no contact
With any children?
with any child.
If you let her out, we don't object. Put her on a tether and set her bond at 5,000, 10%. No objection.
Okay, but then I have the other issue that if she were let out, the location, at least is known, of the children are in very close proximity to where she would need to reside, which is my other concern.
She's already got a condition for release on a tether, so you know where she's at.
I don't know that it's much of an issue.
I can get another address, sir.
Okay. Don't interrupt the judge.
I'm sorry.
The concern that I have is it's not a home confinement tether. It is just an exclusion zone, which, given the addresses given, the children would be residing within that exclusion zone.
Understood. She said she'd give you another address.
Well, I don't know anything about that. I mean, maybe she should have talked with counsel about that.
Well, we don't know where the kids are. To see if there's going to be any
Right.
violation.
I know, and I understand that, but I also know that as of Friday, or at the time of the arraignment, one child was one place, the other two were at some other location with someone. Now I get here today and am told that all three of them may be someplace else. Now, granted, on Friday, I did not have any information or any indication that CPS was involved. I was going to imagine that they were going to be, but I didn't have any of that information. So I don't even know where these children are at this point.
And that's why I said CPS involvement. She's fighting this case and now she got to deal with CPS too.
Well, I don't know, right? I mean, I can't say anything about what CPSs will do or not do. I just know that. All right. The magistrate in setting the bond, there were a couple of things that so the motion indicates, and from what I'm to understand, that there were indeed threats that were made to at least the victim in this case, the 15-year-old. Both from what the court understands before and after the incident of the stabbing or the injury to the 15-year-old's hand. The bond form, the law enforcement bond form, which may have mistakenly misled the magistrate, indicated that there were no threats. However, there were indeed, or at least there were indeed threats. The other concern that I have is that there is a weapon that is used against a minor, not just in a threatening or assaultive fashion, but in a fashion which then indeed led to the injury and the necessity for medical treatment of that 50. There's further the indication that the defendant or that the victim in this case is fearful of the defendant. In looking at just those facts, the court would find that the bond as set by the magistrate does constitute an abuse of discretion with reference to a PR bond, and then simply without knowing the exact location of CPS involvement, just a GPS with an exclusion zone and nothing more. So the court does find that that's an abuse of discretion. Knowing additional facts, and let me just say this, it's an abuse of discretion because of the alleged conduct of the defendant in this case, and that the court would consider that the defendant would then be a threat to not only the victim in this case, but a threat to the community, and a monetary bond, given those circumstances, should have been set. As we now sit here today, there is the additional information regarding this defendant and alleged activities of violence toward someone else with the malicious destruction of property claim, or malicious destruction of property circumstance. From what I am to understand about that case involves either a boyfriend or ex-boyfriend. There is a concern that the court has, given that I have 2 domestic violence incidents by this defendant, allegations or cases that are domestically involved, which raises additional red flags for the court, and also a heightened belief that the defendant in certain circumstances does indeed pose a risk to the community. Taking all of that into account, I'm going to do 2 things. I maintain the bond that the court originally set, although quite frankly, I believe that I should raise it. And that bond will be, her bond will be set in the amount of $50,000. That's a cash bond. Further, the court is going to order the cancellation of the exclusion zone tether, but should the defendant be released, certainly I would reconsider it, but I would order a home confinement tether as a condition upon her release, prior to her release, should she postpone.
When's the next hearing on this one?
Pardon?
The PCC is already set for June 26th.
Is June 26th.
If we get you a new address, would you reconsider before then? Or
Reconsider which portion?
a 10% privilege?
I will certainly look at anything that anybody presents to me. I'm disinclined to change anything until I have some information regarding where the alleged victim in this case is, as well as these 2 other children and where they are. But at this juncture, I'm not inclined to change it.
Yes, sir.
All right.
Yes,
Thank
sir.
you.
Thank you. I'll see y'all tomorrow.
Yes, sir. 14A in recess.
How you been, Judge?
I'm always good.
I know you are.